right, so what's the topic for today, Katie?
So, the topic today that we will be discussing is a new program that the USPTO is launching pretty soon. It's called the Artificial Intelligence Search Automated Pilot Program, condensing it to ASAP. The new ASAP system, they are having an AI pre-examine the search of the application. So, when an individual or a company is applying for a patent, when they submit their application, they do have to apply to have this AI search the application before it reaches an examiner. Basically, what the AI does is it will pull up prior art, basically pull up an Excel sheet that gives you other patents that already exist that you can qualify as potential prior art issues that examiner could bring up. You don't have to pay for this search to be done, but you do have to apply for it. You have to get accepted, and they are accepting applications up until June 1st of 2026, and they are then capping it.
Yeah, so this is the ASRN, or the Automated Search Results Notice, that comes out of the ASAP program. Maybe one of the immediate criticism here is that, as you can see, there's really not much of an explanation that is given with any of the documents that it cites. I mean, it can cite international applications, or foreign applications as well as US, but I mean, as far as the justification that the software gives for why these applications may or may not be relevant, doesn't really appear anywhere. And if you're in a situation where you can file a non-provisional, these search results may or may not be considered by the examiner. And so I'm not entirely sure whether these would be relevant in most cases. Based off the program description by the USPTO, the software will consider the text, claims, figures of your application, as well as, and it also has a knowledge of classification codes of applications. And it uses this in some way to determine which applications may or may not be relevant. One of the concerns that I have is that people who've performed prior art searches would be aware that the USPTO in their patent public search tool already has a relevancy tab. And that is pretty unreliable as is. I mean, if I'm searching for an application on let's say a software, like a database structure using a node and graphical data structure, it's going to say that the most relevant application is whichever use those terms most frequently. And so we've kind of already seen how the USPTO has had some parameters used to judge relevancy that haven't really been accurate already. And simply slapping AI on this search report, I don't really know if that's going to give inventors really anything that would be of value to them, or examiners that would be of value to them.
But essentially, the AI is being kind of described as this general black box structure. We don't really understand 100% what they put in and what they get out. While there's queries and prompts, you don't really understand how it utilizes them exactly, how it samples the database exactly. So we kind of have just being fed this information, the computer thinks somewhat and provides us with these arbitrary 10 references. So in some cases, that's can be more valuable than harmful. Essentially, imagine a independent inventor. They don't use an attorney or a firm to do a pre-search for them or any kind of search. So they're able to get 10 references that a computer thinks is relatively effective or relevant to their topic. It could be better than nothing, or the worst case scenario, they could be totally nothing at all. But in any sense, it tries to give them an idea of what's similar to their invention out there. One cause for concern might be just essentially in a lot of applications, you'll typically include some background context for the field, essentially. So in your background of your invention, you may mention some minor prior art or something you're building upon in an improvement for your invention. And I can imagine an AI, if it sees something kind of a little more clear, like a patent number or a specific title of an invention, it can say, oh, this is definitely a relevant topic. So it goes there and fills the first 4 or 5 slots of your 10 for the research with things that you're aware of, and 2, you're improving upon already. So they're not exactly 100% relevant, and they don't really capture the nuance and important innovation from your invention. So it could be providing you with things not you're one aware of, and two that aren't like relevant to the actual improvement.
Angela, any thoughts?
About how is this AI system doing it? That's a very good question. We don't have a lot of information. It says that it's taking contextual information from both the CPC classifications as well as, text from the spec, the description, claims, abstract, and then looking for similar prior art. So similar in what way? And that's the question, right? So when you normally have a patent search done, when you do a patent search, what you're looking for is you're looking for elements, inventive elements, right? And not necessarily exact. You're looking for combinations. And so your most similar prior art isn't necessarily going to be the most relevant, actually. Those are two very different things. You could have a piece of prior art that is maybe not that similar, but it's very relevant because it discloses some particular element that in combination with another piece of prior art make it obvious. So relevancy is not the same as similarity. The results, as you saw, is just a list. There's no analysis, there's no mapping of the claims. And the examiner then gets to it at some point. They are looking at the claims. They're not going to be just looking for similarity between prior art and your application. They're going to be looking at the claims. How useful that list of 10 is pretty, it's a little bit doubtful, as well as the fact that we don't even know, as Matt mentioned, whether the examiner would even look at that AI. They are, especially if they are an experienced examiner, they are going to go ahead and do their own search anyway. So their list of prior art is very likely to be just completely different. Based on different criteria. It's hard to say. I think that they're trying, but at the moment, I think that the AI tools are not sophisticated enough to do a true good job at a patent search.
They're probably hoping that AI will be lucky and find a reference that will scare the applicant away and maybe abandon that application. So that's probably one objective that they may have here from what we see, right? Again, it seems to be a black box. We don't have a lot of details. But from what we see, this might be one of their objectives into the dependency. I mean, the AI could be lucky, right, to pull one reference that could scare somebody away and abandon the application. Yeah, that would be good for USPTO.
Yeah, we've seen, I think, in the past, like on a few previous office actions, where when an AI tool guided by an examiner is used, they can produce decent prior art or difficult prior art in our case. But an AI with a human at the wheel, I think, is entirely different than a completely automated search report with very little justification given for its results.
I can see the AI being really useful, as Matt said, in the hands of an examiner, because as an examiner, you're sitting there going, having ideas about what to search. But the hard part is actually then wading through all of the prior art to find, the things that would match your idea. I think the AI might be able to help by wading through a whole bunch. Maybe the examiner, the searcher, has the idea, sets up the search, and then the AI can actually implement the searching, and then would really have to be guided, by somebody to know what to leave out and what to look for.
I agree with you. That will be very useful if they will tell you. The AI will tell us why did it pull a particular reference and where the relevant disclosure in that patent reference is that pertains to a particular claim limitation. Because I think what we are saying here, right, is the reference may be apparently not relevant. However, it could read on a particular limitation in one of the claims, which in combination with other patent references could render the claim obvious. So those are nuances that, from what we understand, this AI tool cannot. It's far from understanding, and reporting back to us, right? Because if that report would include that information, hey, I pulled this reference because it reads on this limitation, and here you find it in paragraph whatever, 126, that might be useful, right?
Yeah, the timing of like when you get the report also is I find it kind of questionable. You get it prior to an examiner actually like committing to an office action or a first action on the record. And so at this point, you've presumably drafted and submitted your claims. And so you get this before the examiner looks at it. Would the indication then, or would the idea at that point be you might file like a preliminary amendment if some of these references do scare you enough? If that's the case, when you just wait for the office action to come through, so that way you're not amending around something that the examiner doesn't even consider to be relevant.
Cost may be a problem as well, right? Anybody wants to chime on that?
Yeah, I think just kind of considering everything, it seems in order to maybe use this system effectively, you kind of do need to have patent knowledge and nuanced patent knowledge. Whether that be somehow your own self, maybe you happen to have that, or most likely you're probably going to want to work with an attorney. If you work with an attorney, obviously the this ASAP program is free at this time, but in order to get that attorney's opinion and help understanding the results of the search, that's going to cost you money to use.
I mean, you get these 10 references, and if you're working with a standard law firm that's operating off of like an hourly basis, you're going to pay your attorney the time it takes for them to go through each of these 10 references, figure out what the AI may or may not have been citing as relevant, and then maybe like draft a preliminary amendment to the claims. It just kind of seems like I'm not really sure what the utility of getting the report would be after you've submitted claims.
Bottom line, I think what we are saying here, to really even try to use the AI report, right, will be an extra cost for the client, inevitably, right? I think, Emily, you were trying to say maybe the applicant could read those references and conclude something which will be, very risky and not advisable. Most applicants will have to work with a registered patent attorney who need to pay for those services, right, to review that AI report and advise whether or not any action should be taken, whether or not the claims should be amended, for example, and a preliminary amendment to be filed. All of that takes time, and it's going to be an extra cost for the client. I could come back with an office action and cite completely different references.
I think also if you have this knowledge on hand, either your own knowledge, which again is unlikely, and most of the time you're going to want an attorney, why not just do an actual patent search?
Exactly. You are taking a gamble twice, I feel, right? If the AI is questionable, it's probably not reliable at this point, then you amend ahead of time, another chance you are taking there. So it just doesn't make much sense to me at this time. I don't really see the value at this point. I think that's the general conclusion we have at this time. Until new information is released and maybe the AI tool is improved, at this point we don't see much value in it. Thank you all.